Thank you so much. I want to thank the organizers of this symposium. The structure of the day reflects a great deal of thought. And I also want to thank the previous panel on freedom of information for the terrific discussion and for helping set up our discussion of leaks of government information, an alternative way for information about the government to get out into the public domain. And before I turn it over to each panelist to make a presentation of between 5 and 10 minutes, I want to just recall Professor Teachout's terrific introduction this morning. And in particular, as you listen to the speakers on this panel, I encourage you to keep in mind one of the themes that Professor Teachout highlighted, and that is viewing the First Amendment as not just a way of protecting an individual's right of expression and making it about individualism, but also seeing the First Amendment in its structural or functional role within our form of government, within our democracy. This is a theme that is true not just for national security-related leaks, but for whistleblowing in general. We often think of whistleblowers and the law around whistleblowing in terms of the right to express oneself and whether or not people who have expressed themselves through whistleblowing ought to be protected in that individual expression. But an alternative frame, and just as important a frame, if not more important a frame, for whistleblowing and leaking, I think, is that structural democratic theory frame of, does the leak serve a public purpose? Is the disclosure in the public interest or not? So as our speakers go through their specific topics, I encourage you to keep those two frames in mind. The pamphlet on the symposium has a little bit of additional information about each of these 4 panelists, each of whom is terrifically well qualified. We're incredibly lucky to have them. So I'm going to just turn it over to Steve Dycus initially, who is going to discuss authorized and unauthorized leaks of information, the history of such leaks, and their role in our form of government. Steve Dycus.
So the government and the media have long existed in a kind of symbiotic relationship. The government relies on the media to help inform the people and also promote its programs. The media are dependent on both on official press releases and on leaks, which is what this panel is mostly about. This relationship between government and media is sometimes antagonistic, but it's also mutually exploitive. There are several problems that arise with the media's reliance on leaks. One is that more often than not, stories based on leaks have to be sourced to anonymous individuals or persons who speak on condition of anonymity. This makes it hard for us as news consumers to judge the veracity of the information. We're forced to rely instead on the media to check and double check the reliability of their sources. Complicating the problem of credibility, although some leaks are unauthorized and maybe even illegal, I'll come to that in a minute, many others are what I call authorized leaks. That is, a release by government officials may be disguised as unauthorized and yet strategically placed to try to sway public opinion. A good example, a regrettable example, is the George W. Bush administration's release of the identity of a CIA operative named Valerie Plame in 2003 in an effort to control a story put out by her husband calling into question the existence of Iraqi nuclear weapons programs. Today, the tidal wave of leaks from members of the Trump administration, I've never seen anything like it, makes it especially hard to distinguish between facts and fake news. Unauthorized leaks to the media have played a huge role in American democracy, especially in recent years. Stories about the NSA's secret warrantless wiretap program in 2005, for example, about the CIA's black prisons in Poland and elsewhere, for example, the torture of U.S. prisoners, and of course, the Pentagon Papers. All of these stories and others have profoundly shaped public debate and politics, for that matter. The term leak is often used as a pejorative, and it's linked very often with the word illegal, easily linked. President Trump, for example, has repeatedly referred to what he calls illegal leaks by former FBI Director James Comey concerning a conversation they had in the Oval Office. But leaks are only illegal if they violate some criminal statute. The most important of these is the Espionage Act. We'll talk some more about that statute in a moment. Needless to say, leaks are almost never carried out by real spies who typically prefer to keep secret the fact that they've stolen government information. There's a widespread and erroneous assumption by a lot of people that any unauthorized disclosure of classified information, any disclosure of classified information is illegal, but that's not so. From the beginning, from 1917, there have been repeated efforts in Congress to criminalize all disclosures of all classified information. All those efforts have failed. Some kinds of classified data may not be divulged without criminal sanctions. Nevertheless, courts have disagreed about the significance of classification in Espionage Act prosecutions. My co-panelist, Professor Kitrosser, has written brilliantly about this. Incidentally, if classification matters, then only properly classified data would be protected. That's a big if. The Obama administration launched more criminal prosecutions of leakers, accused leakers, than all previous administrations combined. And yet, Attorney General Jeff Sessions announced a short time ago that his Justice Department has tripled the number of investigations into leaks that are underway. And back, just to put all this in better perspective, back in February, President Trump told then FBI Director Comey that he ought to consider prosecuting journalists for publishing classified information. Now, I mentioned authorized leaks a moment ago. Are authorized leaks necessarily legal just because they're authorized? In May of this year, President Trump reportedly shared some extremely damaging, or sensitive, I should say, counterintelligence data with Russian officials in the White House, information supplied to us by Israel, and the disclosure which apparently jeopardized a source inside the Islamic State. Don't know why he did that, but the legality of his disclosure, an authorized leak, has been hotly debated. So, leakers leak for reasons that we can talk about. Publishers publish. Most of them, I think, following decisions about what it's wise or safe to put in print. The New York Times, for example, withheld the story about the NSA wiretap program for a year before it was finally put out in December of 2005. So I know my job is just to answer questions and not ask them, but here's one for the panel. Should we rely on leakers and media editors to strike the right balance between self-government and security? And if the answer to that question is no, then what's the alternative? And especially in the face of a populist president who has repeatedly attacked the mainstream media as the enemy of the American people. Thank you.
Thank you. Thank you so much. Next up is Heidi Kitrosser, who is going to discuss recent court decisions and executive branch positions on whether those who are prosecuted for leaks can invoke the First Amendment as a defense.
Actually, Kathleen, are we going to do it differently, just so that Sudha could talk about the espionage
yes,
act
forgive
before?
me.
That's okay.
My
that's
mistake.
Okay.
Yeah,
Although
Sudha.
Mary Rose is going next, right?
No, I'm going.
You're going
I'm
next.
going
Okay, and then Mary Rose.
I'm the anchor.
Oh, you go last. Okay. Sorry.
Sudha, you're next.
Yes.
And so let's see if I can get this right. All right. So I think you're going to discuss the sections of the this makes a lot of logical sense. These panelists are good. So Sudha's going to discuss sections of the Espionage Act that have been used in prosecution of leakers. Right? Awesome. Okay. Go right ahead.
Thank you, Kathleen. So I'm actually really glad that we are doing this in this order, because coming after Professor Dycus's conversation about leaking and how that relates to classification, arguable over-classification, and this notion of some sort of safety valve to allow for the dissemination of information that's not otherwise accessible. I think that it's helpful to understand what tools the government has and has used to try to manage this whole process. So like the first panel introduced this idea of overclassification, I think that was very helpful and useful to this conversation as well. We know that classifying something, and we know that information related to national security together are two potent tools to insulate information from public view, that those are very helpful to the government. We know that when there is FOIA litigation, there's a lot of deference that's given to by courts to government determinations of whether something ought to be disclosed or not. That is true exponentially more in the national security context than I think in most other contexts. There's just not a lot of willingness for courts to step in and substitute their own judgment for something that the government has said, well, it's a security matter, and to the court, you might not understand the import of this, but we do, right? And courts, I think, are very sensitive to that. So that's why the leaking ends up being so important. And I think it's important to touch on something that Professor Dycus closed with, this idea of not only the fact that information may legitimately be very sensitive, but also this concern on the part of the government, sometimes quite rightly, that allowing leakers and allowing editors at media organizations to be the gatekeepers of that information, that sits uneasily with them. That there's a wide variation in what we see in the media, and there's lots of responsible folks, but there's lots of folks who are not. And how do you strike that balance in thinking about prosecutions or ways in which you go after leakers, thinking through this notion of gatekeeping information? So there's a few different statutes that govern, that the government has at its disposal. Government employees who leak diplomatic material have a certain statute, 18 U.S.C. 952, that governs them. The military members who leak information related to national security, when they leak it to a foreign government, they are regulated by the Code of Military Justice. And then anyone who leaks information without proper authorization falls into this kind of catch-all of the Espionage Act that Professor Dycus mentioned earlier. So we're just celebrating, or at least marking, the 100th anniversary of the Espionage Act. And I think it's important to understand the context in which it arises. It's a World War I era statute that arises when there's a deep concern in the government that there is going to be leaking and that there's not enough control over information. And also this notion that there's too much opposition to what the government might be doing in terms of promoting the war effort at home. Soon after this act is put forward, there's a Sedition Act that comes out. I think it's 1918, and that in itself tries to quell this idea of anti-government speech. So it's in a time in which it's seen as really important to try to control and manage this information with the leaking process. So the language of the act itself, the textual language, is very broad, right? It allows people who, with intent or knowledge, that in disclosing information that it may be injurious to the United States, when they obtain, copy, transmit, or receive information related to national defense without proper authorization, they are subject to the Espionage Act. So this is by far the broadest provision that the government has to use. It is the most common vehicle for national security-related leak prosecutions in the 3 post-September 11th administrations that we've had. The intent requirement is quite weak, right? It can simply be knowledge that information may injure the United States. It includes obtaining, copying, transmitting, or receiving. That last bit about receiving information, of course, is the textual justification for the conversations that we see now in the Trump administration that perhaps journalists can be prosecuted under the Espionage Act as well. And it covers any information related to national defense, and that term in itself is writ broadly, and it can be interpreted quite broadly by the government. So it's been a favorite of many administrations for this reason, and for those very same reasons, it has been criticized as a factor jeopardizing free speech and the ability of journalists to do their job. We can see all of these perspectives on the Espionage Act in the last 3 administrations. Actually, there was only one high-profile Espionage Act prosecution in the Bush administration. In 2005, a prosecution of a Pentagon employee who was indicted for passing material to the Israeli government. He was sentenced to 12 years in prison, but that sentence was modified to some months of home confinement, so he did not have to serve that 12 years. The interesting thing to note about this case against Lawrence Franklin was that the initial indictment is not just against him, right, the Pentagon employee, but against 2 lobbyists for the American Israel Public Affairs Committee, a pro-Israeli government lobbying group, who were indicted under the theory that they had received this information. Those indictments were dropped, but you can see kind of the setting of a pattern of at least threatening prosecution of individuals who received this information. And when we get to the Obama administration, this ramping up of Espionage Act prosecutions, and for some of these folks, arguably quite a few of them, they believed that they were doing what Professor Clark referenced in her introduction. They believed they were doing a public service in what they were doing. And I know that later panelists will talk about that aspect of it. But we have a number of prosecutions, right? For one of the most notorious ones, I think, is in 2010 for Thomas Drake, who went through what he thought were the appropriate channels for whistleblowing to reveal financial waste within the NSA. He was sentenced to a year of probation after going through a long, extremely expensive defense of this prosecution. There's a number of other cases I won't go through just in the interest of time, but the series of them shows a pattern of some leak prosecutions that were perhaps what we would traditionally think of as appropriate prosecutorial discretion, people who disclosed information for their own financial benefit or disclosed them to a foreign government, hoping to give that government an advantage, but also prosecutions of people who thought they were disclosing information for the public benefit. And I'm just going to highlight two. One is the prosecution of Stephen Kim in 2014, a State Department advisor who disclosed information about North Korea's nuclear plans. The interesting thing about this is that James Rosen, the Fox News reporter with whom he spoke, was also investigated, and the Obama administration threatened to prosecute him as a co-conspirator. In 2015, when Jeffrey Sterling, a CIA officer who leaked information to the New York Times, regarding the failed CIA attempt to give erroneous nuclear blueprints to Iran. He was sentenced to 3.5 years, but James Risen, the New York Times reporter, was threatened with prosecution under the Espionage Act and subpoenaed to testify in Sterling's trial. He fought that subpoena for many years, and that saga finally ended with the Obama administration deciding that he didn't have to testify. But this goes again to this kind of tactic of intimidation and the conversation in the last panel about who has the deep pockets to defend reporters against this kind of pressure. And the Trump administration only has one Espionage Act prosecution underway. This is of Reality Lay Winner, an NSA contractor who was indicted this summer on charges of disclosing information. So just to close, and we can talk about this more in the questions, we have this pattern of at least threatening prosecution or saying that there's going to be a broad swath of individuals over whom prosecution is a possibility. The language of the Espionage Act at least gives the predicate justification for this. Whether this leads to the actual prosecution of journalists or other people who are just recipients of this information, I think is an interesting calculus for the Trump administration and others, because if they actually prosecute and lose, that's not really good for them, right? But if they threaten prosecution and engage in a systematic, years-long pattern of harassing journalists or harassing other recipients of information, maybe they still wield a stick that they can use. So I'll close there.
Thank you very much. And now,
after that
on the First Amendment.
All right. Well, first of all, I just want to echo all the thanks to the conference organizers and advisors. This has just been terrific so far. The morning panel was fantastic, and I'm very excited and honored to be here along with my fellow co-panelists and moderator. So as Kathleen said, I will indeed be talking about some First Amendment aspects of prosecuting leaks of classified information, and Sudha's discussion of the Espionage Act in particular, which, as she said, is the overwhelmingly sort of main tool or primary tool used by the government in the handful of leak cases, was extremely helpful because in setting up the First Amendment issues, because she explained beautifully how broad the Espionage Act is. And in fact, for the reasons that Sudha explained, the breadth of the Espionage Act is such that, you know, it effectively amounts to something very close to, in my view, something very close to an Official Secrets Act. Professor Dycus is absolutely right that we don't have, you know, contrary to, I think, most popular perceptions, we don't have an Official Secrets Act. We don't have an act that automatically makes it a crime to leak classified information. But the breadth of the Espionage Act is such that it comes very, very close. And in fact, one interesting factoid in that regard is during the Bush administration, members of Congress had asked, I think it was Attorney General Ashcroft at the time, they had asked him essentially to let them know. This was shortly after 9/11, if he could use more prosecutorial tools to go after leaks of classified information. Essentially, they were saying, would you like us to consider an Official Secrets Act? And he did a review and said, really, the Espionage Act gives us all the authority we need. So it's something, you know, I think very, very closely approaching an Official Secrets Act. From a First Amendment perspective, that's extremely important because that means that the Espionage Act does not, prosecutions under the Espionage Act are not context sensitive, to say the least, right? That it makes it something close to a crime automatically to leak classified information. It's irrelevant under the Espionage Act whether the leak, whether you thought it was in the public interest, certainly, whether it objectively, reasonably could be said to be in the public interest, whether so long as the information was properly classified under the very generous executive branch's own standards for classification. So long as that's the case, it's really irrelevant how dangerous the leak was, whether the public interest outweighs any danger from the leak. It's also irrelevant the care that you took in leaking. So for example, you know, classic leak case, as Steve mentioned, the Pentagon Papers case, right? Daniel Ellsberg famously, painstakingly went through the papers, had actually written parts of the papers, so he knew them intimately, did not reveal them all, went through those parts that he revealed with Neil Sheehan of the New York Times with a fine-tooth comb to talk about what should come in, what should not be in. Snowden, by most accounts, also very carefully went through the information with Glenn Greenwald and Laura Poitras, as well as some of their colleagues, and in some cases objected to including information, putting it into the public domain they wanted to include. You know, on the other hand, Chelsea Manning, you know, did somewhat more of a, I don't think it's fair to, may not be fair to just flat out call it a dump, but definitely there was less care. Reportedly in you know, how he sort of parsed out the information. But under the Espionage Act, none of that matters, right? And so how does that square with respect to the First Amendment? Well, if we weren't talking about classified information, this would unquestionably be you know, a tremendously overbroad statute, certainly in many of its applications, would be found to be constitutionally suspect. Why is that? Well, that's because of the ordinary First Amendment standards that usually apply outside of the classified information setting when the government prosecutes speech. Ordinarily, if the government prosecutes a speaker because their information could somehow endanger national security, it's really, really hard to pass muster under the First Amendment. Ordinarily, a prosecution like that will only pass muster if the person subjectively intended to and is likely imminently to cause some sort of breach of the peace, some sort of illegality to break out. However, the handful of cases that have arisen with respect to Espionage Act prosecutions indicate that because leaking of classified information by government insiders was at issue in these cases, that courts really see very little, if any, First Amendment problems. So let me very, very quickly then kind of outline the core cases. And there are not many of them, because even though prosecutions have ramped up, as the other speakers suggested, there have only historically so far been a handful of prosecutions, so just a handful of cases. The major on-point federal case is a 1988 case called U.S. v. Morrison. To date, this is still the only federal appellate court opinion weighing in on the First Amendment ramifications of an Espionage Act prosecution for leaking classified information for general public consumption, in that case to a periodical called Jane's Fighting Ships. And in that case, quite disturbingly from a sort of First Amendment libertarian point of view, a panel or a majority of 2 judges on a 3-judge panel joined an opinion by Judge Russell. This is a Fourth Circuit Court of Appeal, the U.S. Court of Appeals for the Fourth Circuit. And in a 2-judge opinion, essentially the judges not only said that the prosecution is fine, but they gave very, very short shrift to any First Amendment considerations. Essentially, they said, look, this isn't really speech even. This is about an employee who had access to information and essentially did something more akin to thievery than to speaking. He effectively stole the information and misappropriated it. So there's really not a First Amendment problem. Now, that said, there were 2 concurrences in the case. One was actually by the judge who didn't write but joined the majority opinion. Although he joined that opinion, he did concur separately to say, actually, it's possible there might be some cases where there could be a First Amendment issue, but we'll deal with those when we come to them. And, you know, I think nonetheless a lot of judicial deference would be called for. The 3rd judge did not join the majority opinion, concurred separately to say something similar to that other concurrence. And the executive branch itself, in the handful of cases that have arisen, essentially have made arguments that mirror the Morrison majority. And this includes the Obama administration, as well as the George W. Bush and the Reagan and Nixon administrations in the handful of cases before that. They essentially also said this really isn't speech, this is more akin to theft. In the alternative, even if it is speech, you can essentially use the classification status as a proxy for finding the kind of danger that courts would otherwise have to find through a context-sensitive analysis. So in short, the executive also has consistently said there's really not a First Amendment problem here. This really shouldn't even be considered speech. Just a few other cases or lines of cases that have some relevance, so they're a bit more peripheral to leak prosecutions that I want to mention. One is, of course, I think Steve mentioned this case, the famous Pentagon Papers case, New York Times versus the United States. Now, this is usually the first case people think of when they think about classified information leaks. The reason it's not directly on point is because it was a case about a prior restraint against the press. It wasn't about a criminal prosecution, and the court there, of course, in a per curiam opinion, famously said that in this case, the very high standard for prior restraint against the press is not met. But a couple things are notable there. One is that the court did not weigh in on what would happen if it were an after publication criminal prosecution. Second is, again, disturbingly from a sort of free speech friendly perspective, there were a number of concurrences, as well certainly as the dissents in that case, that suggested that if it had been a criminal prosecution, even of the press, not of a leaker, if the New York Times had been criminally prosecuted, that the justices might have been pretty amenable to going along with that what they had an issue with was the prior restraint. Also, one other case that comes up sometimes in these contexts, so it's also not factually exactly on point, is a case called Snap versus the United States. Snap is a pretty well-known case from 1980 involving a pre-publication agreement, essentially just a classic, typical agreement signed by government employee with access to classified information, in this case a CIA employee, saying I won't publish memoirs or things that touch on my work unless I go through some kind of security clearance. He failed to do that, and the government sued for the proceeds to be deposited into a constructive trust. They won. The government often points to that case as again showing how much leeway they should have in classified leaks prosecution context. Because my time's limited, I won't get into why, but suffice it to say, and if you're really curious, we can talk about this in the Q&A, there are really important factual differences. So I don't think, as well as procedural problems in that case. So I think that the importance of that case precedentially can be somewhat overstated. Also, one other thing I'll just mention, in the interest of time, won't get into it, but happy to talk about it more. There is a line of cases involving the rights of government employees outside of the classified leaks context to speak. And people often point to those and either say, well, they're irrelevant to the classified information context, or if anything, they support, giving the government broad leeway here. I actually think that's a little too simple, and I'm happy to talk more about why if anyone wants to talk about that in Q&A. But for now, I'll leave it at that.
Thank you. So batting cleanup, we have Mary Rose.
Yes. Well, I do want to begin by saying how, frankly, honored I am to be on this very panel with these amazing people. And I'm thankful to the Vermont Law Review for including me. This is really wonderful. And I think it's great that we've been putting leakers in context of other issues involving the gathering and dissemination of information. So I thought it was really interesting in the first panel to talk about there are so many problems with FOIA to begin. So if FOIA worked perfectly, maybe we wouldn't need leakers as much. I think we still would, but maybe not as much. If we had more robust whistleblower protections, then that would be also very helpful. But national security employees essentially have no protections for whistleblowing, so that's also very problematic. I thought it was really interesting to hear from some of the panelists in the prior panel about the role of leakers and tipping them off on the existence of documents and information, and also the whereabouts of that information. So there are a lot of relationships between or among FOIA and whistleblower protections and protections for leakers and protections for the press to publish that leaked information. And my role right at this moment is to give you a little bit of background on the reporter's privilege and shield laws. So you understand that piece of this puzzle. It's actually a very complicated landscape. Many of you may never have heard of the reporter's privilege. I know sometimes my students haven't. But those of you who have may assume it's pretty simple. Reporters don't have to turn over their sources. That is not correct. It actually can vary very much on which jurisdiction you end up being in and what kind of proceeding you end up being in. So it's hard to predict at the outset when the information is being communicated from the leaker to the press, for the press to really give any solid promise based on a shield law or a First Amendment or common law privilege that reporter will not reveal the source. At bottom, it's really coming down to the reporter saying, as a matter of professional ethics, I will not reveal the source, and if asked, I will go to jail instead. So what the shield laws or reporter privilege do, our focus, I think, will primarily be on the identity of the leaker. So one thing is it protects a member of the media, or however it's defined in the statute or the privilege, to protect the identity of sources. That's sort of the core. It also can protect the news gathering material. So outtakes, imagine ABC does a story and they have lots of B-roll that they haven't aired. Let's say of an interview of a criminal defendant, that sort of thing also could be protected. Okay, so there are a number of different ways that a reporter's sources can be protected. Can be under the Constitution, First Amendment, perhaps federal common law. It could be under the U.S. Attorney General guidelines, which are not enforceable, but I think they're important. On the state level, there are most states, including Vermont, woohoo, May of this year. If I have time, I'll talk to you about the specifics of the Vermont statute, but almost unanimously, the Vermont legislature adopted a shield law this year. Most states now have a statutory shield law. And other states, like Massachusetts, has more of a common law, state common law shield law, or state constitutional shield law. So just about starting with the Constitution first. There's this Supreme Court decision, Brandsburg versus Hayes, which seemingly would put this issue to rest, at least under some reading of it. In this case, it involved the grand jury proceedings. There were multiple cases that were combined, where the court rejected the reporter's privilege. There's been a long-standing debate about whether this case rejected the privilege entirely under all circumstances or just under the circumstances of that particular case. There was a lot of creative media lawyering that spun this defeat into a victory, and quite interestingly, many courts, lower courts, have recognized a constitutional reporter's privilege, not as commonly in the grand jury context, which was the context of Brandsburg, but in other types of proceedings like criminal proceedings or civil proceedings where the media is even a party. There's been a recognition of this type of privilege. The privilege under the constitutional approach typically is a qualified privilege. So those of you who've taken evidence in the room, or obviously practicing lawyers, you're familiar with this terminology, but a qualified privilege can be overcome if a certain showing is made. Typically, that they have to show that the information is relevant to the case, that there's been an effort, exhaustion, there's been an effort to find that information through other means, and that there's some sort of compelling need for that material. So it can be overcome. Okay, but there's a big, as I said, it's not clear, depending on what proceeding you're in, whether a court will and which jurisdiction, because the circuit courts are very much divided on whether there is a privilege and in what proceedings the privilege will be recognized. Okay, there is, I'm just going to mention, there is no federal statutory shield law. So even though most states, including Vermont, now have one, Congress has never passed a statutory shield law. This is despite efforts repeatedly over time to pass such a law. Now, I will say that the most recent efforts, they're the ones that got the most attention, failed when the whole WikiLeaks scandal came into being. And so suddenly Congress was not so excited about giving the press or the media this sort of special protection. I'll also add that the draft statutes had so many exceptions in them, including a big exception for national security. So, you know, you always have to look at what the statute actually protects. The draft statute there was not particularly great. But so there isn't a federal shield law. Some of the lower courts have started to recognize a federal common law privilege. This is based out of Federal Rule of Evidence 501. So in the federal court, rather than having enumerated privileges, Congress said, courts, we want to give you flexibility to recognize privileges like attorney-client privilege or doctor-patient privilege. So some lower courts have said we should have a journalist privilege, a shield law privilege. But this is very much debated and certainly no sure thing. The Attorney General guidelines. So I'm sticking to federal issues right now. So the Attorney General guidelines are not enforceable, but it's a recognition in the Department of Justice that it should be careful about subpoenaing the press. And part of these guidelines requires the government or the line attorneys to get approval up the chain of command before they can just willy-nilly subpoena the press. And I think that's one of the most important parts of these guidelines, if they're followed. And they, you know, who knows? But we know because there aren't too many, there aren't a ton of federal subpoenas of reporters, although obviously there have been some. Now, currently, these guidelines are under review. Jeff Sessions had made that clear recently. We don't know exactly what provisions have been made are attracting their interest. A couple things changed after the James Risen Sterling case where the government really pushed and got a favorable ruling from the Fourth Circuit that they could compel James Risen to testify. The media, there was a big backlash against this, and Attorney General Holder said he would never send a reporter to jail for doing his job. That does not appear to be the attitude of the current administration. So it's unclear if the review of these guidelines is including this reluctance that is in the current guidelines to subpoena the press. To prosecute the press for publishing leaked information. If it's about the review procedures, there was a provision added in 2013 that required notice to the press whenever the government was going to third parties for information about the press. So if they're going to, say, the cell phone companies to get the journalists' phone records, that they'd have to let the press know first so that the press could go to court and challenge that. So I'm guessing that that's part of what's under attack. So as I said, these aren't enforceable, but I think they've played an important role. So these federal things are all the Constitution, the shield, there's no federal shield law, federal common law, the Attorney General guidelines. These apply in federal court. It's also possible, I'm a Civ Pro professor, if you're sitting in diversity, you may get to apply state law privilege. And there are, as I mentioned, state law privileges. Vermont's law has an absolute privilege for the identity of confidential sources as well as information collected from a confidential source. So that's absolute. That means it cannot be overcome no matter what the circumstance. And the other part of the privilege is a qualified privilege for non-confidential information that can be overcome on a certain showing. All of these privileges may be for naught if the government can obtain the identity of linkers without having to subpoena the reporters. If it can engage in surveillance of phone records and cameras and God knows what other technology, these privileges don't matter at all. I think that they do, and I can talk more in Q&A why it still is relevant, but that is one big concern for a lot of media lawyers today.
Terrific. Before we open it up to the floor for questions, I wanted to open it up to the panel for questions of each other, and I will take the moderator's prerogative and just raise the, perhaps if not a question, then a comment. So, Professor Dycus, in your presentation you said that leaks are only illegal if they violate a criminal statute. And I think that you're making a really important point that in general, there isn't a general prohibition for government officials to give out information. And at the same time, I wanted to, especially in this audience of perhaps primarily law students and lawyers, acknowledge that for government officials who are acting as lawyers within the government, there are non-criminal restrictions on the ability of lawyers to talk about the information they've learned as lawyers. Rules of professional conduct, for example. And in fact, I just wanted to give an example of one particular lawyer who was disciplined, I believe, last year for a national security leak in connection with the Reisen and Lichtbau disclosure of warrantless surveillance. And that lawyer's name was Thomas Tam, and he worked in the Justice Department, in the Office of the Justice Department that dealt with FISA foreign intelligence surveillance warrants, and he believed reasonably that there was illegal surveillance going on, and he believed that trying to disclose it within the Justice Department would have been futile, and so he provided some information to the New York Times. There was a criminal investigation of him. He was not criminally prosecuted ultimately, but he ended up leaving the Justice Department, and many years later ended up getting charges, bar charges, filed against him by the DC bar for disclosure of confidential information. And ultimately, I believe, they came to an agreement where he was censured, that he acknowledged the violation of the duty of confidentiality that lawyers have, and was censured, but didn't lose his license, wasn't suspended. But in deciding that censure was the appropriate remedy, the panel acknowledged that this was someone who had been under criminal investigation for years, had been essentially hounded out of his DOJ job, and they didn't put it quite this way, but this was a man who acted in good faith and had been put through hell for acting in good faith, and so censure was the extent of his professional punishment. So I just wanted to acknowledge that the legal situation for government lawyers, for any lawyers, but anyone acting as a lawyer, is going to be, there's going to be an added layer of regulation.
And I would add to that, there are other kinds of sanctions. So, short of a criminal prosecution for leakers, they could suffer some sort of adverse job ramifications, maybe be stripped of their security clearances, which basically put them out of a job, and never mind the whole cultural the culture of government agencies where leakers are reviled and ostracized. So there's that as well.
Contract liability, as in SNP, for example. Yeah, I use the term illegal as in illegal leaks more narrowly to describe, and I think this is how the term is used erroneously to mean leaks that could lead to criminal liability.
Fair enough, fair enough. Other comments from the panel? If not, oh yes.
There are a lot of moving parts here, and I just want to ask about a couple that are, I think, are confusing. The Espionage Act, 18 U.S.C. Section 793 D and E, condition liability on the release of information that the possessor has reason to believe might injure the, that is national security information that the possessor might, has reason to believe might injure the United States, and the release has to be willful. I don't really know what that means. In the language of one recent court, the Rosen court that Sudha alluded to, it seems to mean bad faith, but I think the jury's still out on that meaning. So here's a question. Why do leakers leak? It's a broader question. But second, does it matter? Does motive play any role in criminal liability in this area?
Well, I have argued that it does. I do think that it's at least helpful in the respect that, as Sudha pointed out, the Espionage Act, by its name, seems to be contemplating spying. And so, at the very least, it seems to matter to whom the leak is made and for what purpose. I mean, at the very least for punishment, I would think. And there's a little bit of a distinction in the statute, but there could be much more. A lot of the rhetoric is that all leakers are traitors and criminals. One of my colleagues, he jokingly said, when I defend leakers and the press who loves them, he says, "Why do you hate America?" And so there's that, that concern that leakers are taking matters into their own hands. They're irresponsible. But I do think at a very minimum to whom the leak is made and for what purpose should matter. I don't think the current law does reflect that.
Just a couple of quick add-ons to relating specifically to those last couple of points. One is, as Mary Rose suggested, I think for the most part, certainly where government insiders are at issue, as opposed to the slightly different context in Rosen. The courts really seem, the few courts who have looked at this, really seem to take a very broad view, one that doesn't depend on, who you leaked it to or level of sort of certainly subjective bad faith. But in response to that, some proposals have been made, that would kind of put more context sensitivity into the law. Yoki Benkler, whose name I'm probably mispronouncing, at Harvard, has a great article where he suggests a public interest defense, an affirmative public interest defense, that, which I think might have a somewhat more realistic chance of passing muster than, expecting courts to dramatically change the approach they take from a First Amendment perspective. Also, this relates to, what Mary Rose just mentioned, which is that, and as Sudha mentioned, the Espionage Act, minus a few amendments here and there, is 100 years old, and it was meant for the most part to deal with classic espionage or spying. So, much of the confusion and problems and ambiguities in the law stem from that it's being used for things it wasn't meant for. So it really is due a reworking. I'm not holding my breath for that to happen anytime soon, but it really is due a statutory reworking.
And if I could just add on, I think that a legislative solution, even if it seems far-fetched or unrealistic right now, is actually what's necessary, also because courts, in lots of national security contexts, not just dealing with leaking, tend not to want to second-guess the government. They're very shy about that. Even, we're just past 16 years out from the September 11th attacks, but that rhetoric of the fear of a future terrorist attack, and somehow if some information that's leaked might relate to another massive, large-scale attack, that puts fear in courts, right? And you can see it in the rhetoric of opinions that come out in a lot of different national security contexts. They view terrorism often as an existential threat to the country, and they don't want to be the people who are, without some sort of congressional imprimatur, saying no to the executive branch, right? That's an overgeneralization. There are some courts that kind of challenge that narrative a little bit. But it really is, I think there needs to be a concerted effort from multiple branches of government to try to scale back on the idea that the Espionage Act can be used very broadly just to tamp down dissent or tamp down what is clearly public interest leaking.
Are there questions from or comments from the floor? Yes, if you could hold your thought until you get a microphone so we can all hear it. Thank you.
Hi, I was just wondering if the panel could talk about the recent leak from yesterday morning from National Security Advisor McMaster, basically stating that every department, both military and civilian, should have training on how not to leak, and if that's unprecedented or, yeah.
Yeah, if I could, I just read I think a BuzzFeed article about it about 2 hours ago. And so if I could just expand and bring hopefully everybody up to speed. McMaster sent, I believe, a memorandum to all agency heads directing them to have at least a 1-hour training session that would occur next week and would involve, I think, all hands on deck, the entire agency, all personnel at the agency, to address the unauthorized disclosures of classified and controlled unclassified information. So and I think it was BuzzFeed that got a hold of this, and I think they noted that the memorandum itself that they provided is probably might be an example of controlled unclassified information. So anyway, I open up to the panel.
Go ahead. I went first last time. You go first.
Oh, thanks. Thanks, Mary Rose. We're so polite up here. Just two quick thoughts. One is, of course, I'm not the first to observe that it's amusing that an anti-leak memo immediately gets leaked, which I always find to be a hopeful sign that it is really difficult to if people within the government are concerned and think something wrong is going on, that it really is hard to fully keep information flow down, though certainly not impossible, and it happens all the time. My other thought is, and I would be really curious if others have thoughts about this on the panel or in the audience, I don't know how new this really is. The Obama administration had a pretty robust insider threat program. So I don't know that this really is much new other than the excitement of the leaked memo. I do think, by the way, what is new in the Trump administration, apart from the fact that they claim to be ramping up even further leak prosecutions, is rhetorically what is different is in the Obama administration, Obama went after leaks and he sort of tried to keep it quiet, which wasn't so great and for its own reasons. On the other hand, Trump is going after leaks very bombastically, but he's also doing it in a manner that I think is often designed to distract from more substantive things that are going on. So if he doesn't like something that's leaked out, he says, let's talk about let's talk about the illegal leakers. So that is one difference. But I'm not sure that this memo really suggests a break from the past.
Yeah, what she said. So it's not really new. I mean, having a session on the same day across the U.S. government, I'm not sure how effective that will be. I think other measures have been more effective. So, for example, and this is not new, this was under Obama as well, and perhaps before, labeling each version of a document a slightly different way, for example, so that if a document does get leaked, the government can look at it and know exactly who must have leaked it, because each document is unique. Now, that won't work with a lot. I mean, one of the problems is there's so much information flowing around Washington, and so many people have their hands on it or access to it, that's not always going to work. But that's one way. And reality winner was identified by using technology as well, and sort of narrowing down who was the leaker. The other thing is to have these leak prosecutions. Although there's a drop in the bucket compared to the vast number of leaks that we've always had, and maybe a lot more now, I would think that that would be a deterrent to some leakers, unless they're particularly motivated, because there is this chance that if they are discovered, that they will be prosecuted and their lives completely ruined in every possible way. So I think those are, perhaps more effective ways. There are other methods, as Heidi was alluding to, this insider threat program, putting on very strong restrictions on the ability of government employees to even speak to the press at all, never mind about classified information. So I would second what Heidi says, is that this is really not new. I think the rhetoric is heated. I would say it's also not new to try to deflect attention from the information that's leaked and focus it on the fact that they're a leaker. When the New York Times published the NSA surveillance story in 2006, we saw the same kind of thing where the government was referring to the New York Times as a traitor for publishing this information. So that kind of deflection, I think it is, because so much bad stuff comes out a lot, I think it's happening more often, where there's this deflection onto the leaks as the story. But again, I don't even think that is new, but it's the heated rhetoric that's at a heightened state.
And just to add on to that, I think the Obama administration, after the Edward Snowden disclosures, really ramped up these efforts to try to create better tracking information within the government. This is part of the whole insider threat initiative. And I think that has deterred people, because I think this notion of anonymity is something that's very important to a lot of leakers for all of the reasons that have been discussed, not just criminal prosecution, but stigma and loss of security clearance, which can mean the loss of a career for a lot of these folks. So I think there's a lot of deterrent effects there. I think that the interesting thing about the McMaster document is it seems to be trying to be a less kind of ham-handed effort than what Sean Spicer tried to do some months ago, of like collecting people's cell phones and looking at them, which was just fodder for like late night comics for days. And so they're trying. I think this is part of General Kelly's efforts to try to enforce discipline and try to get that to move throughout the executive branch and the agencies. And there's a lot of fits and starts in this, and I see this as part of the larger pattern of attempting to control something that so far has not been really controllable by them.
I just would add that the phenomenon of focusing on the person who provided the information on the leaker and vilifying that person is a phenomenon that exists outside of the national security context as well. It's absolutely typical of what happens to whistleblowers in all sorts of contexts. So rather than focus on the disclosure, focus on and vilify the discloser, and that will, the goal is to turn the public conversation from the alleged wrongdoing or danger that was being disclosed to the person doing the disclosing and their alleged character flaws, motivation, whatever. And along those lines, I just want to flag what I find kind of interesting, I'm not sure what to make of it, which is the characterization of national security leakers in particular as arrogant, as taking on themselves a responsibility or a privilege to disclose that is improper. It's as though they are, trying to, they don't recognize their place in the scheme of things. And it's this characterization of national security leakers as arrogant that I find particularly intriguing in a democracy. It's not that there isn't any argument to justify that characterization at all, right? But that kind of moral judgment I find intriguing.
Yeah, that's fascinating. You know, the press also can be called arrogant for publishing, but what I wanted to highlight is that we have had this distinction in the law between the rights of, say, government employees and the rights of the press. Now, it does remain to be seen what rights the press would have if and when a member of the media gets prosecuted for publishing information, prosecuted under the Espionage Act. But I think the law, as Heidi laid out, is very hostile to government employees and contractors. This idea that they should have any First Amendment rights at all is very interesting. So the role of the worker bee, they should just stay in place and focus and not provide information, when in fact if we don't get information from them, we often will not know what the government is doing. I understand, I do appreciate the arguments on the other side. I do not hate America. I appreciate concerns that there are some real secrets, right? I get that. And I get that it's not always possible for an employee to appreciate the danger that revealing a particular secret will cause. So I get that, but I also think, as Steve pointed out, there are so many instances in our history where leaks have provided such essential information about what the government is doing. There's not an easy solution here, but I just wanted to point out there's such a dichotomy in the law and the First Amendment rights of government employees generally. Like, they should just stick to their job and be quiet.
Well, and again, I want to come back to one of Professor Teachout's slides. One of his first slides showed the change that happened, I think, was it in the 1700s? You look at 1700, and it's the rulers and the people. And by the end of the 1700s, it's the people providing authority to those who are governing the people, who actually have to serve. And in a sense, that characterization of arrogance, I think, may lark back to that early 1700.
Although actually what's really interesting is at least one iteration of that kind of damnation of or damning of government employees that I've heard actually frames the Government Employees Act as undemocratic, and the argument is we elect the president who, essentially has control of the classification system, determines how it would work, determines who has classification and declassification authority, and for some, bureaucrat to take it upon themselves to, kind of subvert that whole process is actually undemocratic, which is actually of a piece with, kind of a larger school of thought in constitutional literature about presidential power, and, any exercise of presidential power actually is very democratic because of the president being nationally elected, et cetera.
Other questions? Yeah, if you could just wait for the microphone. There it is.
No, I just wanted to make an observation about that, that reaction to whistleblowers. I think, the sexual molestation charges, rape victims, like, we see this sort of focus on the person but if you look at the schoolyard, right, the tattletale is telling, this sort of dislike of the whistleblower goes all the way to that, but there's a really important difference, right, is that person is trying to leverage the authority against, the sort of group. So the tattletale goes to tell the teacher, right? But here it's the people, and I think we see that reflecting that's the same sort of authoritarian attitude about employment at will and all of these kinds of structures where we say, know your place. The church offered these, like, it's going to undermine the church if people find out that this stuff is going on. And it is a dilemma about how do you run an organization once you give somebody authority if you don't let them exercise that authority and they're constantly being, I don't know. Yeah. So it's just
interesting.
If I could just add quickly, I think the attachment of the adjective arrogant to all leakers is unhelpful, frankly. Just consider the examples of Chelsea Manning at one extreme, who did in fact dump everything that she got possession of without discrimination, and Daniel Ellsberg on the other, who knew exactly what he was releasing to the New York Times. So I think we really need to look at each leaker, and I think motive should matter if it doesn't, and we need to think about, I can't imagine a mechanism for discriminating on this basis, but it seems to me that just calling them arrogant doesn't do the job.
We have 3 more minutes. There's, yeah, the woman in glasses.
Doesn't narrow it down.
My question is about the term classified that apparently appears in the Espionage Act. I think it means something very specific. It doesn't appear in the Espionage?
No.
Okay. So it's a term that people think they understand. It is an umbrella term with classifications within it. So 2 questions. Number 1, if one of you could educate us about what the classifications are. And secondly, if you could opine about whether you think it is deliberately misused, either to over-include or under-include, and McMaster's memo to throw in this new controlled unclassified, which I fear can mean anything that's created by any government official anywhere ever, to make sure that every government document falls under a huge umbrella. Would appreciate your thoughts on that.
So who wants to do that in 90 seconds?
I'll give it a quick try. Okay, so it does not, the Espionage Act is actually older than the classification system, which itself dates back to, I guess, about the 1940s. I think it was shortly after World War II that it was brought in beyond the military. So it doesn't include the term classified, but it does refer to information being closely held by the government, and implicitly refers to that by using terms like giving it to one not entitled to receive it. And courts at some point, I think mid-century, brought that, imputed that into the Espionage Act, that we can interpret what's closely held or not, partly by reference to the classification system. As to the different categories, I won't get into all the ins and outs of classified information, but I guess a few sort of key factors that relate to the question of how broad is it are, one, that although there are some statutes that classify particular types of information, overwhelmingly the classification system is a product of the executive. It's pursuant to executive order that the system's laid out. If you count people who have so-called derivative classification authority, that's everyone with some sort of classification security clearance, which is over 4 million, I think, at present. And so that lends itself to a lot of breadth. I think the other kind of nice shorthand way of capturing the breadth is to say that, really there's long been widespread agreement across the political spectrum, and it's not partisan. I mean, this comes from members of, past Republican administrations, including George W. Bush's so-called classification czar, a guy named J. William Leonard. He's been one of the most outspoken people in talking about how overbroad the classification system is. So there's wide agreement, and has been for decades, that there's massive overclassification. And that's only if you consider what falls outside of the very broad classification criteria that the executive himself has created.
Despite what the Fourth Circuit Court said in the Morrison case in the 90s, about classification being an indication of damage to the United States. More recently, the Rosen Court said that the fact of classification may be suggestive of willfulness or of damage to the United States. It's not in any way dispositive.
Well, thank you so much, and I'll turn it over to Amanda to give us direction.
Thank you to all of the panelists.